She put the boys down, she walked in, and when she was met in the other room by the defendant, he locked the door, he took the phone, he turned it off, and then very quickly it escalated into an angry confrontation where he put his hand around her neck, pushed her up against the wall, pulled a gun out from behind his waistband and put it to her head.
He's an American citizen with zero record who is being accused of something that happened at closed doors, with her word being the only evidence. In fact, all the evidence seems to indicate that it's not true. She said it was in a closed door and phones were turned off before they got it. We do agree there was an argument that proceeded, but none of the physical violence, none of the threats, none of the death threats. He denies all of it. He always has. We have video of them in the intervening time between the move that was planned for months, everybody acknowledges that, whether she had second thoughts at some point or not, and the alleged assault that occurred when they say the 12th and the 18th when the move occurred.
Him to spread the private information to discuss this case in particular, and the state has been told by the victim that there have been communications back to her that have made her fear even more the pressure from the outside. I have not been privy to that mail, and I've done that on purpose, but I understand the effect that it has on other people. What I have been privy to is the publications that we also handed up to you.
I think it's interesting they bring up using people's real names as if that in itself is just a threat. They requested that the victim's name not be used in these hearings the last time, and yet she came in and the first thing she said was a defense witness's full name in court. So someone that's asking that their name not be shared immediately to come in and say defense witness because they think it's threatening for their witnesses, it's a little disingenuous when they seem to be doing that game. I don't think that these are implicit threats. I think that he does want the world to know about the situation, but I think a lot of this stuff people should know. If there are white supremacists in the FBI, that's news even I'm curious about. As for this charge, I think most of this stuff is irrelevant. They want to get into his past. They want to get into, which is no criminal record and no history of violence. They want to get into his political views. The political views are shared by the victim in this case. She reached out to him over that and worked for him before they started a relationship.
Danger to the victim to have a warrant dismissed. The underlying allegations are dangerous, and the campaign to continue to influence witnesses or influence people to influence witnesses and the victim shows a disregard for the safety of anyone involved in this case. Because of that, we would ask you to continue to deny the bond.
On that bond hearing, we indicated that it was going to be set for trial at a very soon date. In fact, we set the case for trial, and we're originally going to do some pretrial hearings this week. Due to the coronavirus shutdowns of the court and non-essential hearings and juries not being brought in, it's indefinitely postponed. We don't know when we'll be able to have trials again. So that delay is another significant change of circumstance. And the last is the increased danger within our jail and in any enclosed place. We think also rises to make a change of circumstance.
I'll issue a written order sometime next week. Thank you.